Time is important, and we know that everybody's probably sat through a lot of webinars lately. So I'm Wendy with Preferred Benefits, and today we have a special guest, my friend and colleague, Rachel Kutai. She is owner of My Business Resource, and she is one of my most trusted HR folks that I go to when I have odd questions. She will be the first to tell you I always call her when I have something weird.
Likewise. Good morning, everyone.
We've worked together many years, so that's a good thing. So I'm going to start with a few legislative updates, and then we'll turn it over to Rachel for the bulk of the presentation about HR challenges and solutions during this crisis. I know certainly our office has fielded a lot of questions, and I think Rachel will shed a lot of light on what you should be doing. One thing I want to start out with, first of all, is the country is officially going to open up May 1st on a slow basis, so I'm really excited for that. I know all of you are too. I am over the working at home, and we'll be very glad when we get back into an office routine and I'm not working at my dining room table. And I've said this the last two presentations. If my dogs bark, I apologize. My husband is trying to hold them at bay. Next slide, Joe. So we do have a big agenda today. However, I'm going to take just a few minutes and then Rachel will do the rest. So we'll get through it in an hour. And as with our other webinars, if you have questions, please email them to our info@PrefBen mailbox afterwards, and then we will make sure we release the slides, the recording, and answers to all those questions afterwards as well. Next slide, Joe. So quick legislative update. We don't have a lot as of today, but probably the most exciting is stimulus checks started arriving. So if you or your employees haven't received theirs yet, make sure you check the IRS website. They are recommending you do not call them for this, but you can go to their website. I have heard it has crashed a couple times due to the traffic, but definitely that is the avenue to find out when your check is arriving. So I have a couple updates on the emergency disaster loan and paycheck protection. As of yesterday, both of those funds have been exhausted at this time. So you can no longer apply for a new EIDL or PPP loan until Congress approves additional funding, which we are certainly hoping happens very soon. There are a significant amount of small businesses that still need this help. And I know some of the groups that we work with have applied but have not received funds. I've talked to groups that have received their PPP loans. So it seems to vary, and I have not been able to determine a rhyme or reason as to who got theirs faster than someone else. There are two other types of loans you can apply for through the Small Business Administration. There is an SBA Express Bridge Loan, which is $25,000 or up to $25,000, and then SBA Debt Relief. And what these were designed to do, the SBA Bridge Loan is a loan that enables your small business who currently has a business relationship with an SBA Express lender to access up to $25,000 quickly. They are also providing financial reprieve to small businesses during this pandemic through the debt relief program. The good thing is these are both in addition to the emergency disaster loan, which was $10,000, and the PPP. So employers should visit the SBA website to learn more about those two programs. Next slide, please. So you may not have heard a lot about this. It is the Main Street Lending Program. So on April 9th, the Federal Reserve issued guidance for the distribution of $2.5 billion in loans to support the economy. There are two types of loans as part of this, and these regulations are not finalized yet, but they are designed to further facilitate lending to your small and medium-sized businesses that were in good credit standing before the crisis. And the definition of that small to mid-sized business is they have less than 10,000 employees or less than 2.5 billion in 2019 revenue. And there are two types of loans: a Main Street new loan, to issue a new loan, or Main Street expanded loan, which just increases the size of an existing loan. And you can learn more about these at the federalreserve.gov website. Next slide. So the good news about these is if you applied for a PPP, you may also take out one of these two Main Street lending programs once it's finalized. They are a 4-year unsecured loan, and they have a 1-year deferral of principal and interest. So something else to consider, and as always, when we get more guidance, we will let you know. Next slide. So I do want to take a minute and pause, and let's talk about the employees and all of us. I want to remind everybody, use your employee assistance program. Please get that information out to your associates. This is a very stressful, uncertain time. It's financially troubling. There's a lot of anxiety. We're all dealing with more stress as we work in a, most of us, unfamiliar environment. We're at home. We may have little ones. We may have pets. We may have parents we're taking care of. The employee resource or employee assistance program are free. They're confidential. Some medical plans have them attached. Most all disability plans do as well. If your company does not have an EAP that is attached or freestanding, maybe you purchased it through Matrix or ComPsych, United Healthcare and Aetna have both stepped up and offered their EAPs at absolutely no cost to everybody, whether you are a United Healthcare subscriber or an Aetna subscriber. So even if you don't have either one of these for insurance, your employees can use these numbers. The Optum helpline, we will again send the slide deck out. They also have, United does a Sanvelo app, and that is an on-demand emotional helpline. You can download this in your Google Play Store or your App Store if you have an iPhone. Aetna's EAP phone number is here as well. Please make sure to push this out. I think it's ever really important in these times that we all take the time to take care of ourselves. And this is going to go on for a long time where people have to adjust to what's happened and getting back to what is normal. So with that, I'm going to turn it over to Rachel, and she will take it from here for the rest of the program. I'll come back in at the end and kind of do a recap and a reminder about any questions you may have. Rachel, it's all yours.
Great, thank you, Wendy. So today, what I wanted to do was to touch on a variety of compliance and regulatory concerns that business owners and HR professionals need to be aware of. And some of these apply differently depending on your size of company and industry. So I am going to talk about this like it applies to everyone, but it may or may not directly apply to your business. And there's a lot of information here. So like Wendy said, after we send the slides out, please reach back out to us if you have questions. And it's a good idea to walk through these items with your team and in your business to see how they apply to you and if there are any changes that you need to make in your business. Next slide. So the overarching thing to keep in mind is that whenever you're making employment decisions or policies, that those policies need to be consistent and based on objective facts. They cannot be based on someone's protected class, and that's what Title VII prohibits. So Title VII prohibits discrimination and harassment based on protected classes. And for the purposes of COVID-19, the one that we're going to really focus on, and I have examples for, is national origin. So national origin is a protected class. The Department of Labor and the EEOC has reminded employers that these laws are still in effect during the pandemic and that they are especially in effect during the pandemic. So what are some examples of how this might happen? For instance, it would be unlawful to segregate Chinese employees who are asymptomatic because the coronavirus began in China. That would be discriminating against them because of their national origin. Even making statements and jokes targeted at someone's protected class, like Chinese or Italian employees, because coronavirus is prevalent there, are prohibited under Title VII. And I'll bring this up a couple more times in the presentation, but just as an overarching rule, that is not something we can allow in our business. And we don't hear as much about national origin as much as we hear about race and gender identity all the time. So I wanted to make sure that we were paying attention to that as well. Next slide, please. So I-9. So I'm going to talk a little bit about the changes that the flexibility that the Department of Homeland Security is allowing some employers right now. So this provision applies to employers and workplaces that are operating remotely. If you are an essential business and you're still open, you're still going to the office, no exceptions are implemented for you at this time. So the standard rules apply. You need to complete those forms within 3 days of the person's start date. As always, you need to see the physical original documents as always. However, if you are operating remotely, you can inspect those Section 2 documents remotely. So someone could take a picture of them and text it to you, they could scan it to you, however you can view those remotely, you are allowed to do that during the pandemic. To note that, and I've highlighted in the kind of red box that I've overlaid on the picture of the I-9 form, you need to write that that's because of COVID-19. And then once we return to work, you need to see the original documents and note the date that you physically examined those. Next slide, please. So to complete the form, to complete both sections of the form, you can email that form to the employee, have the employee complete Section 1, sign and date it, and email it back to you, or take a picture of it, send it back to you. Once we go back to work and once operations resume and we're physically present in the office, the employee should bring you the original signed copy. These regulations are in effect for 60 days from when the pandemic started or within 3 days after the termination of the national emergency. So we need to kind of keep track and pay attention to when that is. But that date that you're going to write as the in-person completed date is the date that, if you were to be audited, would be the starting point for those impacted employees. Next slide. In addition to all of that, there is a new I-9 form. So this form was actually released in October of last year, but I wanted to put it in here because we are all required to use this new form by May 1st, which is just around the corner. So we want to make sure that we're using the new form. It looks very similar to the previous form, so check the date at the top to make sure that you're using the right version. And the reason that this is important is because there are penalties attached to it if we don't do these things correctly. So if you're not using the correct form, if you're missing information, if you don't have an I-9 form at all, those penalties range from $230 to over $20,000 per violation. And again, if this is new information, hopefully it's not, but if it's new information or you're not sure if you've got everything and if it's filed the way that it's supposed to be, this is an area where our team has a lot of experience. We can help you audit your I-9s and set up a system for you to make sure that this is not something that you have to worry about moving forward. Next slide, please. So the next regulation we're going to talk about a bit is the Fair Labor Standards Act. So this is the act that establishes minimum wage and overtime pay and how we keep those records. Again, this applies to everyone in the United States. Next slide, please. So this is the law that we reference to determine if someone is exempt or non-exempt from minimum wage and overtime pay. To be exempt, employees have to pass 3 tests. There's a salary level test, a salary basis test, and a duties test. So if an employee passes all 3, we can then consider them exempt from overtime. Next slide, please. So what has changed with this? So January 1st, and hopefully this is a review for most people, we have been talking about this changing for years, I think, but it actually did change. The new regulations were effective January 1st. The minimum salary requirement increased from $455 a week to $684 a week. The duties test did not change. So what does that mean? That means that if an employee previously, let's say you had an office manager and they passed the duties test, you'd give them enough kind of independent judgment to be an exempt employee. And let's say they made less than $684 a week, but more than $455, and they were exempt. That same employee who previously was exempt because of the new salary requirements now is not, and you have to pay them overtime. Next slide, please. In addition to that, this is new. Employers are allowed to use non-discretionary bonuses, incentives, and commissions for up to 10% of that minimum salary requirement, as long as that is paid at least annually. So this is new. And there's a catch-up payment provision, and I'm not going to go into a lot of detail with that, but this is something new that previously was not in effect as it related to overtime. And then next slide, please. The last thing that changed is there's a highly compensated employee exemption, and that dollar amount went up as well. It previously was $100,000 a year. It went up to over $107,000 a year. So as employers, we can expect these to change more frequently in the future to adjust for inflation. So this is something to keep an eye on, these rule changes, and adjust accordingly. Next slide. So this is something that I've been asked about and has come up in a couple of different ways. So everyone is looking for, how to help small businesses, how to help all of our businesses. I wanted to remind everyone, however, that if you are a private for-profit employer, your employees cannot volunteer for work. They have to be paid at least the minimum wage. They cannot volunteer their services. So, for example, if your employees are furloughed, so they are not coming to work, your business is not essential, they're not working, they're all on unemployment, but you want to have like an optional weekly call with them to update them on your business. If that weekly call is about work, you have to pay them for that time. So those non-exempt employees would be paid for the amount of that time. Your exempt salary employees must receive their full salary for any week which they work, regardless of how much time they're doing that. So this could be a huge trap for employers to fall in inadvertently. But if you are a private for-profit business, your employees cannot volunteer, and that's pretty black and white. So please remind your teams about that. Next slide, please. So lots of us are working from home. And as employers, while we do want to be flexible with remote workers, what we need to avoid is people working off the clock. So the FLSA is reminding us that we are required to maintain accurate records of hours worked for everyone. So we definitely need a different system. So if your employees were, swiping in and out or however that is, we need a new way. So you may be pulling out old Excel spreadsheets or templates. But we are required to pay non-exempt employees for all of the time they work, and so we need to capture that. And that can be a challenge. This was something that was challenging before the pandemic, and certainly will be challenging now. So we want to make sure we capture all of that and are paying people for all of the time they are working. Next slide, please. So this is a question that we've got a couple times as well. Can we charge missed time to vacation and leave balances? So this, for the state of Ohio, so if you have employees in other states that have paid sick leave, you have to follow that law, but the state of Ohio does not regulate vacation time and leave. So what will regulate it is your employee handbook or your emergency preparedness plan, if you have that. So that's what you have to follow regarding how to use time and how to accrue time. So this might be a good time to review that and see what it says. Are your employees granted time? Can they use it? Have they not been earning it if they've been off? And does that policy fit for their current situation? Next slide, please. So the next thing I want to talk about is the Americans with Disabilities Act. And there's a lot here that has kind of changed for employers. We are doing things which normally in a quote unquote normal situation, questions we would never ask, we would never be allowed to ask. So I wanted to review kind of what's appropriate right now, what we're allowed to do, what we're encouraged to do, and things that would not be okay to do. So this is directly from the EEOC. This is their advice on how to handle these situations. So what if you have an employee who calls in sick? What are you allowed to ask them? So we can ask during the pandemic if they're experiencing symptoms of COVID-19, and those symptoms include fever, chills, cough, shortness of breath, sore throat, We can ask if they have been tested for COVID-19 and what those results are. If our business is open and we're screening employees when they come to work, what are we allowed to ask then? So we can ask about those symptoms. There are some additional symptoms as well that are now associated with the virus, and those include loss of smell and taste, nausea, diarrhea, and vomiting. You can ask if they're coming into the office if they've been tested for COVID-19 and what the results are. And this is another area where we want to ask everyone the same questions and not discriminate who we're asking which questions to. You may be taking people's temperatures. That is allowed. Typically, measuring somebody's temperature is a medical examination, but because of community spread, we are permitted to take temperatures. A fever per the CDC is 100.4 degrees or higher. However, some people with COVID-19 don't have a fever, so that's why we might want to also ask those additional questions about symptoms. So if you're asking all of these questions, and let's say somebody has a fever, or somebody has some of these symptoms, are you allowed to send them home? And the answer is yes, because their presence in the workplace would pose a threat to health and safety. So the answer there is yes. What if someone refuses to have his or her temperature taken or to answer those questions? We are allowed, the EEOC's position says that we can bar them from the workplace under those conditions. You would obviously want to document that. So let's say you're open, but you're not screening everyone. You're not taking temperatures every day for whatever reason. Are you allowed to just check one person's temperature? And the answer there is yes, if you have a reasonable belief based on objective evidence that that person might have COVID-19. So for instance, if you have an employee who has, let's say they have a persistent hacking cough, you can ask them, have they been to the doctor? If they are aware if they have COVID-19 or not. And the reason we can ask those questions is because that symptom of coughing is one of the symptoms associated with COVID-19. One of the things that was not new information to me, but I hadn't really thought of before I was putting this together. We are not allowed to ask if someone has a family member with COVID-19. So the Genetic Information Non-Discrimination Act prohibits employers from asking medical questions about their family members. And when you think about this, it does make sense. Asking just about family members is limiting the possible extent of someone's exposure to COVID-19. It's not a genetic disease, so that's not the right question. The better question is, have they been exposed to anyone diagnosed with COVID-19 or has those symptoms? Whether they're your family or not is really not relevant to where we're trying to go with the question. So, so those are some things that we're allowed to do and want to document, and we'll talk more about kind of documentation. Next slide, please. So when someone returns to work, can we as employers require them to have a doctor's note? And the answer is yes, but we need to remember that doctors right now are really busy, and they might be too busy, especially if someone has been in the hospital, to provide that documentation. So we would want to consider other ways that this might be provided. Just yesterday, I read an interesting counter argument to this. Apparently, this is an area where that is rife for fraud. So people are forging these doctor's notes as well. So this is one that you're really going to need to look at and determine how you want to manage that inside your company. But there should be some documentation about the person being allowed back to work. Next slide, please. So a little bit about OSHA. So the link in this presentation, when you get it, is actually a really nice guide on how to prepare your workplaces for COVID-19. And as Wendy said, some of our businesses may be reopening here shortly. It has great things like how to clean, what substances to use, those types of things. So I suggest downloading that guide. It's not very long. It's easy to read to kind of make a checklist for your workplace to keep it as safe as possible. These are not new regulations. So it is not mandatory, although certainly recommended that we follow that. As it relates to record keeping under OSHA, COVID is a recordable illness. And so if you are responsible for submitting those records to OSHA, we have to record COVID if it's a confirmed case, so if there's a positive test, and if it is work related. So that is very specific. Because there's community spread, and depending on what kind of employer you are, what industry you're in, it might be very difficult to determine if someone contracted COVID at work or not. So OSHA is not enforcing that record keeping requirement, except where it's objective that COVID is work related. Next slide, please. So this is a question that I know Preferred plus our business has got a lot and that we've had to deal with. So what if you have an employee who refuses to come to work because they're afraid to be exposed to the coronavirus? How do we handle that? So there isn't, this is situational. So these are just things to keep in mind if this comes up in your business. So the first thing is that being afraid to come to work is that person is not entitled to leave. So they are not entitled to emergency sick leave. They're not entitled to the expanded FMLA. They're not to be given any kind of accommodation under the ADA. So there is no benefit to them financially to do that. On the other side, on the employee side, there are two different regulations that protect someone. So an employee who refuses to work because of safety concerns could be engaging in a protected act under the NLRA. And under that law, we are prohibited as employers from retaliating against employees who engage in that protected activity. The second piece of that is OSHA. So under OSHA, an employee can refuse to work if they have told you about the danger and you fail to remediate it, that they're doing that in good faith. Even if they're mistaken about the risk, they still have protection. You can't retaliate against an employee for expressing a safety concern under OSHA as well. So my advice here is to consult an attorney. There's, in the instances that have come across for us, this is a bigger conversation. There's probably several other things going on, so that's why we can't give a yes or no answer, but certainly before you take an employment action, like firing that person, that could be considered retaliation depending on the facts. So just be careful in this instance if this comes up in your workplace. Next slide, please. So HIPAA, the privacy rule, the Health Insurance Portability and Accountability Act. So this is in effect during the outbreak. So we have received that guidance from the government. So this is the rule that prohibits us as employers from releasing someone's confidential medical information. And we are only allowed to do that in certain circumstances, which we will talk about as it relates to the coronavirus. Next slide, please. So what are we allowed to disclose? So per the EEOC, our files, and I'll say files, whether those are physical files or we have an HRIS and we're keeping employee information electronically, either way, medical related information cannot be in someone's general personnel file. So what does that mean? So for instance, a doctor's note releasing somebody to come back to work is not medical information. It can be in the personnel file. Their manager can know about obviously that they've been out. That's an excused absence. That's not medical information. Anything though regarding someone's symptoms, their diagnosis, that is medical information, and it has to be separate, locked, and apart from personnel files and with restricted access. So FMLA records, someone's documentation about sick leave, all of that is confidential information, confidential medical information. If you are taking employee temperatures, that is confidential medical information. So that's the definition of that. Next slide, please. So how this kind of applies in real time is, what if you have an employee who's tested positive for COVID-19? What should you do? So this is where we're kind of combining all of these items. So That guidance from OSHA about keeping our workplaces safe, plus the EEOC's advice, is that if someone tests positive, we should send them home. And we should send home all employees who work closely with them to ensure that the infection doesn't spread. And how much time should they be off, and all of those things that's medical information, and they should consult their doctor about that. The important part here that I want to talk about legislatively is that when we're doing that, we never want to identify the infected employee by name. So if we're in a small business, employees could probably figure that out, but that is irrelevant. We are not allowed to confirm that employee's identity. Now, if that employee wants to tell everybody that they were positive, that's their information and they're allowed to release that. But as employers, we are not allowed to do that. Next slide, please. So if someone is suspected but not confirmed, we would want to treat that the same way. And there is an exception to this with critical infrastructure workers. They are allowed to continue to work if they've been exposed, if they're asymptomatic, and there's additional precautions that need to be implemented there as well. Next slide, please. Next, workers' compensation. So this, I haven't heard about this as much, but I would imagine that this is something that as we return to work is going to be more prevalent. So is someone allowed to, if someone says that they contracted the coronavirus at work, is that going to result in a workers' compensation claim? And an important thing to remember here is that workers' comp is a no-fault system. That means that the employee doesn't have to prove that the employer was negligent. What they have to prove is that the injury, and this isn't an injury, it would be an occupational disease, but that occurred at work and it was proximately caused by their employment. So they're going to have to show that they're contracting COVID was because of conditions specific to their workplace and to their position that was greater than the risk than how they would have contracted it just in the general public. So the answer here is yes, probably we are going to see workers' compensation claims claiming that someone contracted the coronavirus at work. Next slide. So some recommendations, that was a lot of information, I appreciate that. So like I said, take a look at this later. It can be overwhelming, but my advice is just to kind of look at it one step at a time and see if you're in compliance with those areas or not. So some recommendations. One is to create the forms that we need to administer and comply with COVID-19. While there's been a lot of kind of questions and answers and advice, there haven't been forms released for how we're supposed to document, though we have been told that we need to document. So you're going to need to create those forms. The second thing I recommend is to update your employee handbook. This situation may have exposed some gaps. Plus there are, and we'll go through some slides, there are some things just kind of in society and in the state that are changing that may require us to update our handbooks as well. And then last but not least would be to stay close to your expert resources for updates and assistance. Next slide, please. So what are some recommended documentation that we suggest? So there's a long list here. I'm not gonna read it, but again, this would be a great checklist for you to see, do I have these things in place? And if not, then I need to create them. You don't want to be in the situation where someone says, hey, I need pay time off. I want to take advantage of that, and you don't have the forms to address that and to document it. The link to the I-9 form I talked about is here. So just some recommendations for how we communicate moving forward. Next slide, please. Updates to the employee handbook. So these are some suggestions. Obviously, you know, this is dependent on everyone's handbook and how long it's been since you've updated it. But these are some things that you will certainly want to consider when you're updating your employee handbook. Social media, reasonable accommodation, drug-free workplace, anti-discrimination, working from home, telework, paid time off, and company property. Next slide, please. And I'm just gonna touch on a few of those things. I'm not gonna read all of these things to you, but just FYI, if you didn't know kind of what's happening legislatively with some of these things. So medical marijuana is now permitted in Ohio. there are 21 medical conditions that are eligible for a medical marijuana referral, not a prescription, a referral. So that's kind of what's happening in the state. That does not mean that as an employer that you need to allow marijuana in your workplace if you have a zero tolerance policy or a drug-free workplace. There's lots of flexibility there, and there are things that we're certainly not allowed to do. For instance, just because someone possesses a license, we can't terminate them just because of that. But you can discipline or terminate someone who tests positive if that's against if marijuana use is against your policy. Next slide, please. Social media, I think we've been talking about social media for a long time. I think given now that everyone is home, or lots of people are home and working remotely, people may have more opportunity and feel like expressing themselves more on social media right now. And so that is, employers are very sensitive to that for good reason. There's a potential risk of damage to your brand and reputation. On the other hand, employees do have protected speech, whether they're in a union or not. And we as employers can't infringe on their right to engage in protected activities. So we want to make sure that we understand where the line is as it relates to our policy and how we practice that. Next slide, please. Anti-discrimination. So there are more and more protections for the LGBTQ community. State laws protecting the law protects state employees from discrimination here in about 30 cities. In Ohio have anti-discrimination ordinances. This is something that you probably want to have in your handbook and in your practices, and include these things in your sexual harassment training, that it would fall under your anti-harassment policies and training. Next slide, please. Pay history inquiries. This is not effective throughout the state yet, but it will be effective in Cincinnati and in Toledo. And if you have employees in other states and other cities, you're probably already aware of this. What this is a ban on asking someone what their salary history is. And the reason for that is to try to start to address gender pay inequality. So if I, as a woman, have not been paid the same as my male counterpart, if I tell you what my salary has been, and even if you pay me more than my last job, that salary is still being set based upon, theoretically, a discriminatory practice. So what we are supposed to ask is what someone's expectations for salary are based on this position. The suggestion is that you create a salary range and that you pay the person you hire within that salary range based on things like merit, education, experience, but not gender. Next slide, please. And then my last recommendation was staying in touch with your expert resources. It is impossible to know all of this, to keep up with all of this. It takes years and years and years in just a normal circumstances to become familiar with all of these regulations and how to use them and how to combine them in real time with real situations. So like Wendy said at the beginning, she and I think are talking every day, almost as questions come up. So your resources, keep them close. If you don't have relationships, establish some relationships here so that you have people ready to help you in your business. So for instance, your broker, your payroll company, your payroll rep, there are payroll tax credits, and how do you take advantage of those? Your accountant, there are lots of other tax credits, and so you want to make sure that you're close to them and they know what's happening in your business so that you can take advantage of those when you file taxes. Your banker, so that you can take advantage of some of these loans. Your lawyer, I strongly recommend that you have an employment law attorney, as some of these things may come up and need to be litigated. I really think that you need to have somebody with experience doing that, specialized more than just a business attorney, and lots of attorneys will tell you that as well. A third-party administrator, and that's very common with workers' compensation, but there are TPAs for unemployment as well. And I think I have probably answered more unemployment questions than anything. So many people are filing for unemployment, and so many people have never done it before, and the unemployment system is overwhelmed. with those questions. So answering a lot of questions, a TPA can help kind of take that off your plate as well. Plus an HR consultant if you don't have HR in-house, and even if you do, to have an extra set of hands and eyes and ears is not a bad thing to have either. Wendy, I'm going to turn it back to you. That's all I have.
All right, thanks, Rachel. Hey, we did have a question come up in the chat box, and I think I know the answer, but I'm going to defer to you, Rachel. The question is, if an exempt employee does not work on a given day in their regular work week, can we require them to use PTO or vacation or not pay them for that day?
So those are two different questions. So can you require them to use PTO or vacation? The answer is yes, that's what your handbook says. Can you not pay them for that day? That falls under the FLSA. So that is docking someone's pay. So if they are salaried and exempt, that is docking someone's pay, and you can only do that in given situations with the FLSA. So I would refer back to, why is that person not working, and is that an acceptable reason? Typically, it has to fall under those reasons. If it's not, you're paying that person for the entire week.
Okay, thanks. Well, I am going to close it out as my dogs have started barking. Again, if you have any questions, contact Rachel or myself. You can also please email our info@prefben.com, and we will submit the recording and the PowerPoint out on our YouTube channel and LinkedIn, and we'll email it. Thanks, and have a great day.
Thanks, everybody.